That's all we have, the declaration of Mr. Beeford, and he may have some additional information for the court that he can share with regard to uh, the issues he's having with this bank.
Okay. So it sounds like there may be some brief testimony from him on that.
Yeah, if any, it should be brief. Yeah.
Okay. Let's go ahead. I'm just going to mute and stop my video just until I see him pop in.
Is that him there, the Cowlitz County virtual courtroom? Is that
No,
possible?
that's our clerk.
Oh,
That's our clerk's login. So I should see him here any minute. If I don't see him by the next 5 or 6 minutes, I'll pop back in and we'll figure out if we're just going to move forward. Okay. All right.
awesome.
I'll check back in with you in just a minute.
Thank you.
Okay, I think we've got everyone here. Mr. Beefert, I believe that's you in the iPad number 2. Is that correct?
Correct, yes.
And then Ms. Cotto, I think your client has logged in as
Yes,
well.
in the event I need testimony from him, depending on if I didn't realize the court was taking testimony. I thought this was just for.
Go ahead.
I wasn't aware that the court was going to take testimony today. So my client is on in the event that the court is taking testimony. I thought this was strictly on pleadings.
Okay. Well, I hadn't really made that decision. I think my statement previously was just based on Mr. Brunetti stating that Mr. Beefert might have some additional information. And if that's the case, then I would put him under oath. But let's go ahead and get started. Obviously, if Mr. Beefert does give any brief testimony, your client, of course, would be allowed to do so. 232008570. My understanding is we are here. I'm going to go through my understanding of the history of this case because some of it has involved me and some of it has not, just to make sure we're all on the same page. As I understand it, there was a court-ordered payment plan entered on October 2nd, and subsequent to that, it looks like ex parte, there was an order enforcing, an order staying the enforcement of writ of restitution, but it didn't look like an actual order for writ of restitution was signed at the time the payment plan was entered. So subsequent to that, on or about November 2nd, 2023, Ms. Cotto did file this motion for order of writ of restitution. The allegations at this point are that Mr. Beefert has failed to comply with the court-ordered payment plan. So as I understand it, the issue before me is whether essentially to find Mr. Beefert in default of the court-ordered payment plan and to issue or sign the order for writ. Does that sound correct to the parties?
Yes, Your Honor.
Well, I think we're putting the cart before the horse, because here's the problem. In the contract, which was signed, it says that if he's in default, I may enforce my client may enforce the writ by serving a notice of default. I've never got the order for the writ, and then Mr. Brunetti jumped the gun and came in on an order staying the writ, but we've never had an order for the writ. So for me to invoke any portions of the contract, I need an order for the writ. So,
well, and that was one of my questions, because how I typically do these, if I'm going to enter a payment plan, I first have to issue the order for writ, and then we go into whether a stay is appropriate and a payment plan is appropriate. So usually how I've done it, usually there would be an order for writ in the file, then the payment plan is ordered.
That's how it should be done. And what occurred is I was on vacation when this was entered, because I anticipated that at the same time there would be an order for writ. And I actually sent over an order for writ. I don't think the court has that. I couldn't see the filings.
I don't. Yeah, we looked before this matter started. We don't have an original order for writ.
And so at this point, I can't ask for enforcement of the writ or that he's in default until I get the order for the writ. And then the contract is real clear. It says, should he default, I may enforce the writ under these conditions, and I have to serve a notice of default. And so I can't even do that. That's why I had originally requested that Mr. Brunetti sign an order for writ, which he said, no, his client's entitled to argue against the order for the writ. But I think I'm entitled to that, period, because we entered into this court-ordered plan. And so then the next step would be, he's in violation, he's in default. If the court wants to decide all of this today, that's fine. But I'm asking the court for the issuance of the order for the writ. And then at that point, I can move forward on the default for the contract.
Okay. Mr. Brunetti, I'll hear from you. I think my inclination is, as previously stated, that an order for writ should have issued at the time the payment plan was entered. So I am inclined to sign that. And then if both parties are in agreement to continuing on to the default hearing today, we can do so. Otherwise, I can certainly give you a new date.
Your Honor, I would agree with that. I think that the statute would contemplated the issuance of the writ when the court-ordered payment plan was issued. So I would have no objection to that.
Okay.
Our position here today would be that the court could go ahead and issue that writ. We're just asking that the court modify its order or continue the stay under its equitable powers due to the circumstances that Mr. Beefert put in his declaration. So that is our position.
Okay. And Ms. Cotto, are you okay with moving forward on a default hearing?
Yes, yes. So I will,
Okay.
I will then get over and get Mr. Brunetti a resend and I don't know what happened, but I will get the order for the
Okay.
writ at least sent to all parties so we can get that piece of it. But I would like to proceed on the motion for because then it turns into a motion for default. Because I have not served Mr. Beefert for the contract. It says that I'm to serve him with a notice of default. I did include that in my materials.
Yes, I see that.
Yeah, I did include that in my materials, but I did not serve him, but I served his counsel. So I would suggest to the court that if the court is going to issue the order for the writ, then I can proceed on this notice of default.
And it sounds as though both parties are in agreement to have that heard today.
Yes, Your Honor.
And you've both.
And if I may say, I don't mean to interrupt,
Go
that
ahead,
I was
sir.
Mr.
fraudulent
Beefert,
and
Mr.
my account was hacked into.
Oh, hold on. Yeah, hold on, Mr. Beefer. It sounds like you're getting into the merits. You are represented here today, so I'm gonna hear from your attorney first. And then if they need additional information from you, we'll get to that point, okay? So this is Ms. Cotto's motion for default. Ms. Cotto, I do have the declaration of Mitchell Norton that I have reviewed along with your original motion that did include the notice for default. Would you like to give a statement on this?
Yes, Your Honor.
Okay,
so
go
I
ahead.
think a portion of what my motion has been kind of resolved in the respect that the court did issue the motion for the writ. But I think what's important here is we have an agreed contract. The contract is very clear. It says that Mr. Beefert will pay payments on specific times. And that was $1,237.33, which was due on the 29th of October. That wasn't paid. And he is also under provision number 4 of that same contract where Mr. Beefert was represented by counsel. In fact, counsel drafted that order. It also says he'll remain current in his ongoing rent, which was November and December, because we contemplated this contract, that the payments would be made in full by a certain date. And then if Mr. Beefert complied with those requirements under the contract he signed, his counsel signed, my client signed, that the unlawful detainer would be dismissed. So November 1st, no payment. Now we're actually November 8th today. Not only has Mr. Beefert not made the payment for October 31st or October 29th, he hasn't made the payment for November's rent. So we are definitely in violation of the contract. And so the only issue here is my client is entitled, he has complied with all conditions of the contract. Mr. Beefert has been staying at the apartment. He's been living at the premises. And Mr. Beefert has violated the contract. And this isn't the first contract he's violated. He had a repayment agreement, and I provided that in my materials, the supplemental materials, where he had a repayment agreement with my client back in May of last year through DRC. And he didn't comply with those contract agreements. And that's why this matter got filed. And so the concern is we've got a valid contract. Everybody was represented, everybody signed, and clearly the conditions are he's to make the payments. He hasn't made any of the payments, and this is an ongoing issue. My client is entitled to the writ of restitution. Mr. Beefert comes in now and says, well, I've been hacked. When you look at his materials, he says, well, I was hacked. He provides a letter from the bank, but that doesn't say what his bank balance is, how much he was hacked, but that isn't an issue here. The issue is he agreed on a contract, and he hasn't complied. And the concern I've got is if the court is going to allow Mr. Beeford to get out of this contract based on, well, I have this hacking or I haven't been able to pay my rent, what's the point of even entering contracts? What's the point of having repayment agreements? Because what's happening is then it allows the one of the parties to just pick and choose what they comply with and what they don't. If the landlord was in violation of any portion of this contract, the court would definitely be enforcing that. But because it's the tenant, well, then, do they get these second chances? Do they get these excuses? And I would submit to the court, it's clear this is the second contract Mr. Beeford has now been in failure to comply with those terms. And we supplied his rental history. Huge problems coming in is, yeah, we understand that there was COVID and he got rental assistance. But when you look at this in the totality of all the circumstances, the second agreement, the court should not only, and the court's going to, the court should issue a restitution. I've got that. It should not be stayed. There was a stay granted somewhat prematurely because the order was never entered. But there's a basis here, very clear, it didn't comply with the contract. So we're asking today that the court allow the writ of restitution to be served on Mr. Beeford, and keeping in mind that the sheriff's office, even if the court issues it today, the sheriff's office will not serve it for 5 days, not the 3 days as set forth in the agreement. And it's time to get this matter settled. Thank you.
Thank you, Ms. Cotto. Mr. Brunetti.
Thank you, Your Honor. And Your Honor, I just want to note that I turned my video off because I'm having some connectivity problems.
Okay.
I did miss some of the things that Ms. Cotto said, but I think I got the gist of it. And I'm just going to try to proceed as best as I can with my camera off here. But Your Honor, just wanted to, just to comment on a few things. This was an agreed order, so I'll concede that there is some contractual aspects to this, but this is, it's a court order, and the court should view it as such. And I'll admit there really isn't much case law here. So with the inception of the Right to Counsel program, we're finding out that there's a lot of issues of first impression out there, and this would be one of them. But I do think that this case should be viewed as under the court's ability to modify its own orders, and there is substantial case law on that issue in other contexts. I think the case that I found that was most on point here, Supreme Court case from 2019 entitled Randy Reynolds and Associates versus Harmon. And the citation to that is 193 Win Second 143. And that was a case that arose out of an unlawful detainer action. And it was a bit of a different context, but it dealt with the court's ability to grant stays. And, the Supreme Court held that courts possess inherent equitable powers to furnish remedies as justice demands. And they derived that from Article 4, Section 6 of the Constitution, which discusses and gives superior courts their equitable powers. So really, I think that's kind of how the court should look at this legally. And I'll also note that, in my research, I saw lots of cases in the realm of, family law actions, child support, custody, where the appellate courts of this state have repeatedly affirmed their authority to modify court orders. I think this is a similar type of context as a child support situation. And just going back to the Randy Reynolds case, which was a UDA case, what we're asking for here is just a further stay of the writ of restitution, which the court is issuing here to give Mr. Beefert an opportunity to catch up. And as his declaration describes, this was really something that was sort of out of his control. I think he'll probably concede that yes, he fell behind on rent. He has been dealing with some difficulties, but in this particular incident, it really was something that was out of his control. And if the court wants to hear directly from him, I'll certainly turn it over to him to discuss further. But what he is telling me that he believes that this issue should be resolved by the end of next week, and that he should be able to provide the full amount that was, I believe, owed. I can't remember the dates. Was it October 29th and then the regular rent payment on November 1st? He believes that he should, by the end of next week, have that full amount. So we would ask, I guess, just in sum, we would ask the court to just continue the stay, modify its order, and give Mr. Beeford a chance here to make those payments.
Your Honor, if I could respond.
Go ahead, Ms. Cotto.
So I don't dispute that the court has the ability to modify a court order, but this is different. We've got it's an agreed contract between the parties. And so you cannot compare what we have here to the modification of a child support order. And I haven't read the Reynolds case, but I'm not disputing that the court can't modify its own orders. But this is a completely different issue. This was a contract between the parties that was negotiated, agreed upon, and signed. And then it was ultimately signed by the court and entered as an order. So you can't, what's the point then at this point of negotiating any agreed orders? Because then you come back in and you renegotiate the contract with the court. And that's what Mr. Brunetti or Mr. Beeford is asking the court is, well, modify this agreed contract because I've had X happen. I would submit to the court that this is not a modification of a court order. They're asking you to modify an agreed contract. And I would submit to the court that I don't think that the case law provides that that's okay. And so I'm asking the court, I think the court clearly could issue the writ based on very simple case law. This is a contract negotiated by the parties. It is not a child support order or a court order that was, the court didn't make this order. Thank you.
If just briefly, Your Honor, I mean, I think lots, child support orders, custody orders are oftentimes entered into contractually and then it's signed off by the court, and yet the courts still say, we can move forward. I did not find, I don't know if it's out there. I'll be honest with the court. Any case law that says where an order has been agreed and negotiated between the parties that deprives the court of its jurisdiction to modify them. I have not seen that case. But again, just leaning on the Randy Reynolds case and this, all the case law that we see on child custody and child support orders, I think that does provide the court with the authority to do that.
Mr. Beeford, I know that you had wanted to speak. Is there something you wanted to add to what your attorney has already stated?
Yes, the time my account was hacked into was the 26th, October 26th, and that's why I could not further to do it because I contact my bank and should get my new card end of this week and make the full payments by the end of next week with everything that's combining and that's going along. So,
okay.
And with it, I'm working on things and I'm trying to combine things, but I should be able to do that, yes, with no problem.
So here's my.
Your Honor, could I have?
But there is fraudulent activities what's going on, yes.
Okay, I'm okay. I'm going to issue my ruling. My ruling in this case, after review of the declarations, the argument of counsel, my review of the original payment plan, my review of the original complaint, what I see here. So I guess I'll back up a little bit. In my reading of the statute, the court ordered payment plans that result in stays of writs really are kind of the court's last chance that we give folks where we think it will make a difference. It is where we're saying to the defendant, hey, like, we think that you can make these payments. We think that you can get back in a better position, and we're giving you one final chance. In this case, I think Mr. Beeford, I understand the court can in equity modify agreements. The court can in equity further continue the stay. but I don't believe that there is enough here for me to grant that. I believe what I see in review of the file is that you've been given 2 chances really to enter into payment plans. And both times there have been reasons, according to you, that you have not been able to fulfill your payment plan obligations. I am troubled a bit that you allege that the alleged fraudulent activity occurred on October 26th, but instead of contacting the landlord right away, you waited for them to call you, and then you told them this had happened the week prior. And then you came to court, and it wasn't until that court date that you got a letter from the bank stating something along the lines of, per your request, we are confirming that we've reissued a debit card. What I don't see in that, and I'm just going to
Thing is, I didn't know
hold on,
about
sir, I'm in the middle of a ruling. I will open it up to you for questions. The November 2nd letter from Advantist states, per your request, I am confirming that you have advised us of multiple fraudulent charges on your account, specifically your debit card linked to your checking account. As a result, we had to cancel your debit card ending in, and I won't read those numbers. We have ordered a new debit card for you. However, this usually takes 7 to 10 business days to arrive. What I don't see in that letter is any indication that your actual checking account was frozen. And all this letter tells me is that they reissued you a debit card. It does not tell me that you were unable to access your checking account. So the only assumption, logical assumption I can make is that you, and given your history of non-payment, I don't believe, even if I extend this payment plan, that you will be able to get caught up. And I don't believe that you will be able to pay your rent. So I am finding that you have defaulted in the payment plan. I will be signing the order for writ that we previously discussed. And as you've heard from counsel, the sheriff's office will be executing that writ 5 days after service. Is there anything else the parties need from me today?
I don't believe. Oh, the only thing I would ask for in the order is that proper notice was given and proper, that we did give notice of the default that's required under the contract.
And if you're going to be drafting that order when you send over the order for writ, I would include in there that the court finds by agreement that the parties both agreed to move forward with the default hearing on the record.
Okay. All right. Understand.
I did not
Mr.
know
Beeford,
about
Mr. Beeford, I could talk with you. Well, unless the court is okay with Mr. Beeford talking, but otherwise I'll.
No,
It's fine. Mr. Beeford, go ahead if you would like to. Otherwise, you certainly can call your attorney afterwards to discuss your options at this point.
Okay. I didn't know until the next day after when I was checking on my accounts to see what's my balance is and everything. And that's when I found out. And I did call Advantis, and it took a couple of times for them to actually get a letter through.
Okay.
But yes, it is fraudulent, and they did put some of the money back in there as they're doing the investigation. So I will have it all by the end of next week.
So why don't you go ahead and what I would encourage you to do is reach out to Mr. Brunetti as soon as we log off today, and he can discuss your options from here. Okay. And then Ms. Cotto, once those orders or order, however you want to do it, have been circulated to Mr. Brunetti, you both are free to email it to the judicial assistant for my signature directly. That's going to go to Autumn because Sylvia is out for the next 2 weeks, well, week and a half.
Okay. I found that out yesterday.
Yeah. So it'll be Autumn T.
Okay.
Is the email. And I'm just trying to think. I am not here tomorrow. If you get it in before 4 o'clock today, I can get it signed and filed. I am not here at the courthouse tomorrow. And of course, we're closed Friday. So if you don't get it over today, Send it over to ex parte docket tomorrow, or not docket, ex parte bin tomorrow.
Okay, I will draft it, and get it to Mr. Brunetti this afternoon.
Okay. All right. Thank you all. I'm going to go ahead and end docket.
Thank you.